So I think what we want is for this to be an interactive discussion, and this is not a lecture. Nothing wrong with lectures, but we are in the company of lecturers. But yeah, we just wanted to have a free exchange of ideas. And so just a bit of background context. So I'm the CEO of the Free Market Foundation, which is a classical liberal think tank. So we are very dedicated to the promotion of individual rights and human freedom and flourishing in South Africa. So that includes a passionate commitment to private property rights. We believe that everybody should have the rights of ownership in South Africa. We're also proponents of free markets. We're capitalists at heart. I often joke that we're capitalists without much capital. But we believe that the free exchange of goods and services in a market economy is the best way to ensure economic growth and prosperity. And so that also entails minimal government. We don't want the state to interfere in your rights. And part of minimal government is also this notion of the rule of law. So although many people think that we're an economics think tank, actually most of the people in our organization have a legal background, actually. So we're very, very committed to this idea of the rule of law, which, as you know, is a key part of a free society, so that laws are generally applicable. They're not, they don't treat people differently based on their power or status in society. We also, underpinning that is this idea that rules must be rational and reasonable and transparent. So the opposite of rule of law is rule by man, rule by the powerful. So this idea of constitutionalism also, in a way, almost sits outside of the Constitution itself. The piece of paper that we call the Constitution is the product of a political negotiation. But we believe that the rights that you enjoy as a human being are fundamental to who you are. They're indivisible. And they're not just sort of policy preferences that may produce efficient outcomes. They're a recognition of your human rights. So that's a bit of the brief background context. My mother often asks me, what work do I actually do? So a lot of what we do is we engage in the policy process. We are an independent organization, so we're not affiliated with any political party. We're happy to talk to anybody who will listen. But our primary interest is promoting freedom. And with freedom also comes this idea of individual responsibility as well. So, I think some of our opponents sometimes, particularly on the right of the political spectrum, tend to dismiss us as sort of these permissive libertines. We're not libertines, we're libertarians. A bit of a distinction. So yeah, and a lot of the ideas that we promote also really put to the foreground this idea that you are a sovereign individual with freedom to choose how to direct your own life, but that also comes with responsibilities and responsibilities towards others to respect their rights. So something like free trade is actually a very important symbol of that idea of voluntariness, of mutual respect and recognition. When you trade with somebody else, that is underpinned by consent. That is a mutually beneficial exchange. The buyer benefits from getting a good that he or she needs, and the seller also benefits by generating profit, and the profit motive is something to celebrate. So a lot of our work, we're looking at the policy domain. We're also very interested in the political contestation for power, because policy is an expression of the political process. But then we're also engaged actively in parliamentary submissions, but we do quite a lot of advocacy and ideas-based work. So if you open the newspaper, you'll see one of our writers passionately defending the cause of individual freedom, engaging on contemporary policy issues, whether it's expropriation without compensation, which we oppose, or whether it's national health insurance. We have a health policy unit which has been at the forefront of opposing NHI. We can get into that if you want separately. And then, yeah, social media, we're very active there. And we also are doing a lot of in-person engagements like this. I just concluded a roadshow through the Southern Cape with my colleague Martin van Staden, who's our head of policy, and we were promoting this idea of home rule. And we can perhaps speak a little bit more about that later. But home rule is really premised on the idea that we need much more decentralized governance in South Africa. And that's part of our philosophy of limited government, actually, that currently we have a high degree of political concentration of power in Pretoria, and that leads to a number of negative externalities, to use an economics term that you'd be familiar with. Yeah, and so what we want to do is to diffuse power down and out to the lowest level of political authority possible. The smallest political unit in society is actually the individual, but we can also think of a political unit being a family or a community, a town, a district, or a province even. And our argument in this paper, which Martin authored, is that the constitutional structure in South Africa actually lends itself to a lot more federal application of powers, and that the relationship with the central government is perhaps a little bit too collaborative, a little bit too cozy, and that provincial and local authorities should actually start to acquire more powers to represent the interests of their constituents. Yeah, so just back to the rule of law question, which I think is what we're here to discuss, and some of our public interest litigation. I just wanted to provide that context for the work that the Free Market Foundation is doing broadly. But we also have a rule of law project, which is specifically intended to uphold and defend this very cherished notion of the rule of law. And it is chaired by Rex van Schalkwyk, who is a former judge. We have many eminent legal minds on that rule of law board. This is a voluntary group, and not all of the participants in the rule of law project are necessarily staff members of the Free Market Foundation. I'm very pleased to be joined by one of the eminent members of the Rule of Law Project, Mark Oppenheimer. And the Rule of Law Project, through its various activities, is trying to uphold this idea of the rule of law. And so we want to ensure separation of powers. We want to ensure that laws are not arbitrarily or capriciously applied. And we also want to limit the power of the state. We feel that there are checks and balances on state power in South Africa, but they're very weak and they need to be defended. And so we've taken an approach which is that we are going to be on the lookout for critical pieces of or opportunities for strategic litigation in the public interest, with this lens of how does it uphold the rule of law. And Mark is a prominent advocate. He's been involved in a number of high-profile constitutional and other matters, public law matters. And I think, Mark, in 1 year you were in every court in the land. I think in 1 month. 1 month. Yeah. Remind me, what was it? The Equality Court, the High Court, the Supreme Court of Appeal, and the Constitutional Court.
And the Magistrates Court too, and the Broadcast and Complaints Commission.
Yeah, don't forget the Mag Court and the Broadcast Complaints Commission. You weren't in the Labour Court that month.
Rats.
Okay, so you can't get them all. Okay, so we'll talk a bit about some of the pieces of litigation that we've been involved in. I think that's actually a good point for me to segue to Mark. And I think the courts are an arena of contestation. And I think that has been a feature of South African politics. There's a lot of lawfare, and we're not shy to participate in that arena. And we're very grateful to have counsel of the caliber of Mark and others helping us in that cause. But why don't I hand over to you, Mark?
Maybe I'll start by talking about one of the cases I ran for the Rule of Law Project. It's reported as AfriSACA versus the Minister of Finance. And it revolves around whether the minister had the power to produce these preferential procurement regulations. The regulations were rather onerous in that you could disqualify bidders to a tender if based on the levels of ownership in the businesses. And what that does, so race-based ownership, what that does is then distort market prices. So you wind up with a situation where those who would have come in with a competitive bid are excluded, regardless by the way, about their employees. So one of the examples of this having effect was Fidelity Guarding Services who joined the matter. So the owners of the company are white, but they employ 50,000 black staff, and they had played an enormous role in guarding many municipal and government buildings around the country. And overnight, when these regulations came in, all those contracts ended. So there was no sense of this being for the benefit of the poor and the vulnerable. It's really a kind of help my mates policy. So all these small towns, the mayor suddenly found a cousin who started a guarding business 2 weeks before they would come in, and at a much higher price because you could remove these guys from the category. So Rule of Law came in to argue 2 points. The one was South Africa as a nation founded on the value of non-racialism, that you cannot have race-based methods for preferential procurement at all. That if you go and look at the language of the original regulations, they're all non-racial in character. So the ones in the 90s talk about people who are disadvantaged. If you look at the language used in Section 9 of the Constitution, it refers to disadvantaged individuals and groups. What we've done instead is really replicate the kinds of things done during apartheid and before then with color bars, to sort of reserve certain work for people based on the color of their skin, as opposed to saying the content of your character matters. So there's this abandonment of non-racialism and the abandonment of the respect for equality. That was our first point. The second point was to say, if you go and actually look at the enabling legislation and what the minister has done, the minister has exceeded his powers. He doesn't have the power to produce this stuff. The legislation is quite narrow, and the minister has seized power unlawfully. The Constitutional Court handed down judgment 5-4. What's nice about this case is that it happened during COVID, so it's filmed. One of the things I'll talk about a bit is how litigation can be a stage, and it's important to be able to express your ideas on a big stage. And so having a record of that is very important. And so the judge who I engaged with for about half an hour, Judge Madlanga, wrote the majority judgment 5-4 and went our way. So for a very small amount of money, we could open up billions of rands of value. All those businesses that were told, you cannot compete, you cannot play any role in this, suddenly could. And so that gives you a sense of the leverage effect that you can have with street litigation. I imagine that a lot of law clinics around the country will fall into 2 camps. The one is there's a particular person before me who's going through something quite difficult. They don't have the money and we want to help. So I'm going through a difficult divorce or I'm being evicted. You say, what can we do to help? And that's a very important thing to do. The other one is when you say, the real hindrance here that we see is over and over again, people are coming in because there's a piece of law that's getting in the way of their livelihoods or their welfare. Can we do anything to change that law? And so that's the strategic element. And often what you need is a good case to run to make that change. One of the things that I've done in a lot of litigation for the Rule of Law Project and for other clients is to try and establish non-racialism in our law in a better way. It sort of pops up in a few small cases around affirmative action. You have various proclamations that we ought not to abandon non-racialism, but that we need some kind of redress measures, and maybe we can pause non-racialism for a bit. There's a question as to when you start to take the value seriously. So I think trying to work out how you identify those cases, it would be nice to say that judges would just look at the abstract question and decide on that basis. I don't think that's what actually happens. I think having the equities in your favor is quite important if you want to win. And also you have to have a stomach for a long fight. The circular litigation, went through 3 courts. I'd acted for John Quilani in a matter where we ultimately struck down parts of the Equality Act will become constitutional. He'd written his article in 2008 and judgment came out in 2021. So you've got to have the stomach for a long fight. I thought this is probably a good juncture to get a sense from you what you're particularly interested in, what issues are arising for you, what strategic stuff you're doing, and I can sort of give you some insights.
And can I ask, for the purposes of recording, we have this roaming microphone here, and I think I'll detach my microphone, Mark, and then if you and I can share your cable.
Sure.
Okay, there was a question over here. If you could just introduce yourself. Comment.
Yeah, thanks, David and Mark, for that introduction. My name is Stefan van der Merwe. I am one of the senior attorneys at the Law Clinic, very much involved in the clinic's impact litigation arm of our activities. And so what you're saying speaks to definitely the business we're involved in, the activities we're involved in as well. And it also resonates from the perspective that we deal with a lot of matters where, as you say, clients walk through the door and we have to assist them with various types of matters. We deal mainly with matters involving evictions and family law, as well as general civil litigation. And we have, over the years, developed quite an expertise in debt and credit related matters. And so that resonates with us as well, that you see clients and you start picking up a trend where there is something in the bigger picture that needs to be addressed, some legislation. And also we align and we can identify with you saying that this takes time, and we've had experience with this as well. And so our clinic has been involved in quite a number of important impact litigation matters, and maybe the most important or the most well-known is the emolument attachment order litigation, where we started early in the 2000s on an individual basis, working with and identifying clients walking through our doors where garnishee orders, as they know, emolument attachment orders, were flourishing at that stage. The university hostels, you had a lot of people working there who had their salaries garnished on a monthly basis to ridiculous amounts. They would basically earn nothing at the end of the day. And so we picked up on that early in the 2000s. We started going to magistrates courts all over the Western Cape with those types of matters. We dealt with hundreds of individual cases, up to the point where we eventually then were in the position in 2014 where Wendy Applebaum got involved as a result of a bunch of these EAOs on her farm as well. And she assisted with finance so that we were then able to approach the Western Cape High Court. And from there, as you'll know, it escalated in 2016 to the Constitutional Court. And that led directly, because of the favourable judgments in those matters, it led directly to the amendment of the Magistrates Courts Act with regarding to emolument attachment orders, where at least now there is a limit of 25% that can be deducted through EAOs on a monthly basis, where previously that wasn't the case. There now is jurisdictional limitations, which again previously was not the case. You'd often find that people would issue EAOs from courts in Bloemfontein to garnish salaries in the Western Cape, which was ridiculous because those debtors couldn't combat that type of matter. So yes, we identified with both of those. We also with saying, as I say, the situation where people walk through the doors and also picking up the more general trends. We are involved currently in a number of high impact matters, to maybe address your point of where we're interested in. We've in the past dealt with some equality court matters as well, where we had an interesting case with Henry Happs, the the Paralympic swimmer who was a blind Paralympic swimmer, where he was refused access for him and his guide dog at a restaurant. And we approached the Quality Court in that matter, which was quite helpful from that perspective, in that we assisted in getting some precedent out there for that. And you had a lot of positive news reports. And I think these days the wine farms in and around Stellenbosch, at least, are a lot more sensitized to the fact that they need to allow guide dogs for blind people as well, to give them access to those kind of farms. We've dealt in a number of important eviction-related matters. We've had some precedent-setting matters there. And then, as I say, within the space of the credit and debt-related environment, we've moved over from the emolument attachment issue to payroll deductions, which is closely related, but is a separate issue, and an issue where there still is no proper regulation. And so we're working with the National Credit Regulator on an advocacy level, but we also have counsel involved in looking at whether it's going to be necessary ultimately to bring litigation with regarding to payroll deductions. Our other very prominent case at this stage that Ottawa can speak to more better than I could is the lifestyle legal class action that we're involved with. And maybe, Ottawa, if you wouldn't mind giving some background and context to that. Thanks.
Yeah, thank you, Stefan. Thank you, Mark and David. Like Stefan indicated, we have matters that we're involved in, and one of those matters is the recent class action that was certified in the Western Cape High Court. It's basically the first class action that relates to consumer rights. A brief background on the matter is that we were approached by a reporter who had identified a scheme. So the basics of the scheme was that there was a website, so different types of websites with the names like Loan Zone, Loan Finder, etc. So what they did is they would, when you type on Google looking for a loan, they would immediately pop up. If you go onto those loan sites and you click on them, then you immediately approached by a form, apply here. When you click on that link, it then allows you to go into a separate website where you make the application under the pretenses that you're actually applying for a loan. But what's happening in the background is that actually you are applying for what is referred to as a legal service package. So it's a subscription instead of actually applying for a loan. So what then happened after a period of a month, the clients then find out that in actual fact, they weren't getting assistance in applying for a loan, but they were actually subscribing to what is referred to as a legal service package. And that legal service package has a subscription of 12 months where you pay the initial fee of 429 Rand. Then thereafter, your account is debited an amount of 99 Rand every month. So obviously the scheme works on the consumer actually not knowing that in actual fact they are applying for what is referred to as a service package, and in their minds they were applying for a loan. So this continues for a period of 12 months, and then you would note that the debit order was only 99 Rand, which means that it doesn't automatically reflect on your phone that a debit order has gone out. So you only realize it once you go and get a statement that there are these 99 Rands. So most of those consumers only realized at a later stage that they were actually entering into a service package rather than being assisted with the loan. So like we indicated, like Stefan said, that class action was certified in the Western Cape High Court. They appealed it obviously up until the Constitutional Court. And currently we're in the process of finalizing the summonses so that the class action can actually begin. Yeah, thank you.
Yeah, thanks, Ottawa.
Yeah, those are fascinating examples. Your class action case, that's quite cutting edge in the sense that we have very few class action cases in South Africa. They're more popular in the States. It would never be worth it for any one individual to ever try and sue to get their money back. And the importance of obviously running that class is to send a signal that predatory kinds of practices will be pushed back on. As you say, it seems to have been designed in a deceptive manner. I assume the Consumer Protection Act is of some service in that regard for subscriptions and deceptive practices and things like that. And then, the emolument stuff is interesting as well. I mean, we think partly as lawyers, we think about the legal questions, but there are other ramifications for laws. And if you think about Marikana, a lot of those miners would talk about their salaries as being incredibly low. That was after the deductions. And so there's a sort of separate effect of reckless lending that can cause this problem that can wind up being, cataclysmic. If you think about the effects that Marikana has had, that ripple is gigantic. And so I wonder, part of what's interesting about the work that I do and what David does is that you've got overlapping spheres. There's the litigation project, but then there's also trying to change public policy in a certain direction. And so I think often the advantage of working with an NGO is that they've got another framework in mind and they have other ways of expressing their message. So either through negotiation with other players in the field, through lobbying to change legislation, or through getting their ideas out there. I think some kinds of cases, the sympathetic client can make a big difference for changing people's attitudes, and getting coverage on those things matters. But it seems like you guys are involved in interesting work.
Yeah, I mean, interestingly enough, I can't really comment on the particulars of that case, obviously, but generally our view is that the regulatory burden on financial service providers is actually too onerous, and that it crowds out a lot of financial service providers. And when you use that term, it sounds very fancy, financial service providers. But a mashonisa in the township is a financial service provider, a loan shark. And, loan shark, that sounds very scary. Mm-hmm. But, for many low-income people, actually, you would think, this is predatory lending, 25%, 26% interest rate, or 100%. But often you have people who need access to a bridging loan. Mm-hmm. For example, if you delivering fruit and vegetables in the township and your bakkie breaks down, you might need some urgent amount of money to help fix your bakkie so you can get back to business. And then you pay off that rather large loan at the end of the month. Yeah, so I think just as a general point, I mean, what we want to say is, like, often you see some kind of symptom in society of some kind of bad practice, and often the first impulse is to say, we need to regulate that or intervene in that. But often there's a second order effect to your regulation that can create other negative consequences, right? Generally our bias is towards letting people be free to make their own choices rather than prescribing to them what their behavior should be. But I think in this instance, it sounds like there was mischief afoot, and a deliberate misrepresentation. Again, I don't really know all of the facts, but and I think something that we often campaign on is this idea of, I think there's also this reflex that government, through the legislative process, should try to intervene to control all of these outcomes in society. But, we forget that there is a long common law tradition in South Africa which deals with all of the nuances and complexities of these kinds of conflicts. And I think maybe we should kind of get back to that in a way as our first preference, to rely more on precedent and this huge body of legal cases that have come before us, rather than trying to regulate every aspect of society. But yeah, that's why public interest litigation is so important.
I'm interested to know how you go about in your decision-making processes to identifying matters that warrant litigious intervention, as opposed to exploring other avenues to effect change. do you have a specific process that you engage in to decide whether you want to engage in litigation before you engage in litigation itself? How do you take a decision on what that specific problem, what type of intervention it necessitates?
Yeah, look, I mean, it's quite an organic process. I don't think we have some checklist. I think if we see that there's a very evident manifestation of the breach of the rule of law, then we'll act. I mean, I think, interestingly, in the context of South Africa, as opposed to, say, other more mature democracies in the developed world, for example, often the legislative participatory process, the public submissions and so on, often for political reasons have very limited effect. The ANC has enjoyed a hegemony over South African politics for so long that it often just blatantly ignores the submissions from civil society. I mean, I think the EWC process is a good example of that. NHI as well. I mean, that NHI bill, despite all of the 113 submissions that were made at the National Assembly, at the Portfolio Committee, that bill basically was unchanged, apart from a few kind of minor grammatical and other cosmetic kind of changes. So that sort of democratic civil participation is actually a little bit weak. And so that actually necessitates much more conflictual approach in terms of going to the courts. I think there might be various metrics at which you evaluate it. So obviously you want to win, but sometimes there is the art of the losing case, right? Like you use it as a platform to also expose a particular idea as well. I think there are a lot of problems in society and a lot of areas in which you could justifiably make a case to intervene. But I think we're also looking for opportunities for leverage. So Mark mentioned this preferential procurement case. And I think with a small investment there in the council fees for that matter, we were able to unlock, as Mark mentioned, potentially hundreds of millions of rands, if not billions of rands, for private companies to continue to legitimately do business with the state. As Mark pointed out, there was a rich irony that because the state was imposing 100% black-owned requirement, a lot of even businesses that were 75% black-owned were excluded from that, not to mention all of the tens of thousands of staff and employees who benefited from working in those companies that were doing business with the state. So I think that is order of magnitude bigger than maybe some other cases, which might be an interesting academic point, but maybe not that consequential.
And funding of the litigation, is that a consideration when you decide whether you want to take on a matter? I mean, is there a budget that you need to function within? Is there a cap on the number of impact cases that you can run at any stage? What are your funding considerations?
Yeah, so the funding model is a bit ad hoc. I think in the past we have benefited from pro bono representation, but my view is that you want to remunerate all parties because then you get the attention and the effort that is required. Whilst we're very grateful for pro bono representation, but I think our preference is to raise funds. And it sort of depends. I mean, in some instances, we will say, well, we've identified this case and we need to move pretty quickly. So let's get involved first and then try and raise money as we go and as we publicize so for the Malema hate speech appeal case where the Rule of Law Project was amicus, and again, Mark was our counsel there. That was what we did, we raised money through a crowdfunding initiative, for example. And then, I know that other organizations have if there's an interested party who would be impacted, they might, potentially be a source of funding. But yeah, like I said, it's actually quite ad hoc. I know Sakeliga actually has a litigation war chest. So they have a track record of success with these kinds of matters, and then they use that to as a justification for raising funds, and then they exercise quite a high degree of discretion over which matters they get involved in. But yeah, our system is a bit more improvised. Yeah. Any other questions?
I'll just say something a little bit on that. I think if you're an ordinary lawyer, if you're doing commercial work, clients come your way with a particular problem and you solve it for them. I think if you're doing public law work, part of what's expected of you is to keep an eye on the horizon to see what are the threats and to mention this to your clients. So some of the strategic work that I did during COVID was quite interesting in that you had lockdown rules being imposed on a very regular basis, causing enormous amounts of damage, maybe with a good-hearted intent. So one of them was early on, they said, well, no one can go to any shopping centers because you might get COVID. They said, well, if you can't go to brick and mortar stores, we should also shut down all the online stores because it's otherwise unfair on the brick and mortar stores. And they're not,
You must punish everyone equally.
And so you thought, okay, well, now you've got a thing that clearly doesn't have a health benefit and is going to deprive people of an income and might keep their businesses alive. So, we lobbied Ibrahim Patel and said, well, you're forgetting that all those brick and mortar stores can sell their goods online. Okay, yeah, that would be good. So we managed to push back on that regulation. We also stopped things like these quarantine centers that were mandatory.
Did that online retail matter, did that go to court, or was it like the threat of the litigation made them reconsider?
Yeah, we found they often, given that the timelines were unusual, because basically you had if you think about those general principles around the rule of law, and you think about Fuller's writing on that, and King Rex and all the ways in which he doesn't make law, one of them is that you've got to have some kind of deliberative process before the thing comes out, and it's known to everybody. You had laws coming out on a daily basis by decree, basically. I mean, we lived under a strange fiefdom during that time, and so sometimes what you'd do is you'd initiate litigation, and they would back down. And so the next set of regulations would come out without it. A good example of that is we ran litigation to end the curfew. And the matter got postponed. I think the High Court thought, well, are we going to have a fourth wave that kills everybody? Do we want to be the ones responsible for it? It's also the festive season. Come back soon. And 2 days later, the curfew was withdrawn. So sometimes they say the litigation doesn't yield a judgment, but it yields a practical result. And those are good examples of that. Funding, I think, is a complicated thing. And David's right to say that if you rely too much on pro bono counsel, I'm sure you will know this, that your brief will always be at the bottom of the pile. Yeah. And so finding a method that is good for funding is useful. And sometimes what rule of law can do is provide a shield. So it might be publicly embarrassing for an organization to say, this is our cause. A lot of corporates are incredibly cowardly, would be a polite way of putting it. And so having an organization that can do something in their interest is a really good idea. And so, rule of law can do wonderful work on that front. And I imagine that law clinics might often deal with a constituency that doesn't really have financial backing at all. In other words, you're dealing with poor, vulnerable people who are largely affected by something like these big deductions in their paychecks. So you then are trying to work out, well, I don't have a corporate interest in this. How do I fund it? And so I imagine on goodwill. I will say that there can be a danger in some strategic litigation. So if I think about an organization like SERI, so you have poor vulnerable people who come in and say, I'm about to be evicted from my place and I have nowhere else to go. So you think, okay, well, it's very important for us to then stop this eviction process. And you do a lot of that. And you say, well, maybe we should stop more evictions. Maybe we can try and create more procedural hurdles or make it more difficult, and that'll be good for the class people we're trying to protect. And so the second order effect of that, of course, is that people say, what's the point in owning a building if you can never get a rent out and you can never evict people? And so the inner city in Joburg starts to crumble. And eventually what happens is you have a fire in one of those buildings and 76 people lose their lives. And some of that is the unintended consequence of a certain kind of litigation strategy. And I do think it is hard to think about all the ramifications of strategic litigation. We're in a big system where lots of things push and pull in different directions. But sometimes the second order effect can be seen as an obvious one. And I suppose that's worth considering, when you're working out where do I put my funds, or, are there other ways I can achieve this objective? Or yes, but I hope that helps.
Very interesting. Any other questions, comments?
You first.
I've already spoken.
Thank you. I'm aware this is talk on strategic litigation, but I have a bit of a different question, if that's all right.
Please introduce yourself.
Yes, okay. I'm Luca Vesta. I did an undergraduate degree in law and economics, and now I'm doing my postgraduate law degree. And I think everyone saw the headlines around October, November last year, which economists were kind of aware of beforehand, but it hit the mainstream that South Africa is out of money. I think it was the Times that said something to that effect. South Africa has like a unique challenge. They often refer to it as the triple challenge because there's unemployment, there's inequality, and there's poverty. And those are three, economists understand it to be three different issues. And dealing with one might exacerbate another one, at least in the short term. Of course, for example, economic growth might or often does have the result of leading to increased inequality, right? So my question is, and it goes for both Advocate Oppenheimer and Mr. Ansara, South Africa's constitution is unique because of its recognition of socio-economic rights in the constitution. And when these talks were being had after the midterm budget speech, it seemed to me, and this is the point that I want to raise, that there's, and what I've observed in my studies as well, there seems to be that in the legal fraternity compared to the economics field, there seems to be different understandings and conceptions of what the problem is and how to deal with it. There seems to be cross purposes there. Whereas a lot of economists were saying we need to deal with our expenditure. The socio-economic rights lawyers were like, but we can't cut spending here. And obviously it has an effect, desperately needed. My question is, what is the interaction between the socio-economic rights per se, and how, and the effect on the budget, with the manner in which also strategic litigation, as you mentioned, with regard to theory, and particularly the judgments made by the Constitutional Court in developing the law, giving effect to the content of these rights. What's the relationship there? Yeah.
Okay. So maybe I'll have a crack. I think when you consider the work of Isaiah Berlin, the political theorist, he spoke about the distinction between negative and positive liberty. So negative liberty would be almost like what John Stuart Mill wrote about, where I have the freedom to swing my fist, but that freedom ends at the tip of Mark's nose. So that would be a harm that would be inflicted on Mark. But so that is a freedom from. It's a negative conception of liberty, that you don't want to restrict people's freedom of expression unnecessarily, for example, or infringe on their private property rights by trespassing on their property. So that's the kind of negative conception. And the state's role there is to enforce contracts and adjudicate disputes through the judicial process. That's quite a limited, narrow function. Whereas the socioeconomic rights that you mentioned, like, say, Section 27 of the Constitution, those put a positive obligation on the state to perform certain functions. And so that would suggest that you have a right to housing, a right to water, et cetera, et cetera. And I think philosophically, we would have an objection to that. So it sounds very nice, but everybody should have water. I mean, you can't survive without water for more than a couple of days, and this is essential to your existence. So many people who are advocates of these socioeconomic rights would say, therefore, the state must be the provider of these services. And that state resources, regardless of the fiscal implications, must be directed towards supporting it. So, I mean, I'm from Johannesburg, so is Mark, and we both regularly have water outages. And our friends and colleagues, often say, "No, I can't come to work today because I'm filthy because I haven't had a shower." And in South Africa, the state is the custodian of water rights. And we are middle-class people, but most people in South Africa actually are low-income people, and they have even worse access to water. But I thought that the state was going to provide water for me. What's happened? There's a bit of a disconnect there, right? So, I mean, we would actually be proponents of the private sector providing water. Private sector does a pretty good job of providing other services and goods. So it's very important that when you do have a shower that you use soap. Being clean and hygienic is very important. But the government doesn't provide you with soap. You go and you buy it from the market. And some people buy fancy soap and other people buy very simple soap. But, human beings take care of their needs. And, so, I think we should get beyond this idea that the state must be the provider of everything. The state must not interfere in your ability to provide for yourself and to trade and so on. But that's a different conception. I mean, if you had to take a reductio ad absurdum, Ferraris are very nice things to have, right? Why shouldn't the state provide Ferraris for everyone? But the state, that would be unreasonable, you think. So somebody has to pay. Somebody always pays, and who bears the cost? And the implications, just to divert into economics for a moment, are very serious. I mean, our debt to GDP ratio over the medium term, I think, is set to escalate to just under 80% now, so in the next 3 years. And National Treasury's projections of that debt rate are always slightly off. It keeps ratcheting up. And so many proponents of modern monetary theory and other ideas suggest that, well, you can just monetize the debt, that the government can keep printing money and they can keep borrowing, and that they can do that indefinitely to fund all of these social services. But what that potentially risks is a rapid rise in inflation. And I think many of these very clever economists, particularly in the developed world, actually, in universities in London and other places, make these arguments. But look at the experience of the people of Argentina, people of Zimbabwe, the people of Turkey. They've all suffered incredibly by the denuding of the value of their currencies and their purchasing power. And it's usually the poor who suffer the most from the rise in inflation, right? A lot of wealthy people have their wealth tied up in assets, in equities or in properties, and so on. But the poor are very dependent on consumption. So a wealthier person or middle-class person does their shopping once a month, maybe twice a month. But a poor person is shopping 2 or 3 times a day because their cash flow is limited. So they really feel the effects of inflation disproportionately to other people. And so I think this is a very concerning development, that you have people making these arguments supposedly on behalf of the poor to say, oh, well, we need these socioeconomic rights and these protections. But actually, often these policies affect the poor the most. And the antidote to that is economic freedom. So the Fraser Institute in Canada, which is a think tank there, they published the Economic Freedom of the World report. And that measures your state of economic freedom for countries around the world, and they index these measures. So one of them is security of private property rights, the other is soundness of money, of the monetary system. Is the state empowered to interfere in the supply of money? Do you have central bank independence, for example? Many of people in our libertarian world don't even think that central banks should exist. Maybe that's a separate conversation. And then the independence of the judicial system is very important, and all of those measures show that the more freedom you have, the more openness and liberalization you have in an economy, the more prosperity rises. And what's very interesting is if you divide all of those countries into 4 groups, 4 quartiles, the bottom quartile, the poor there in the 10%, the poorest of the poor in the poorest countries, they earn about $1,700 per annum. That's the GDP level per capita. Whereas in the freest countries, in the top quartile, the poor people there earn about $14,000 per capita. So if you're going to be a poor person in the bottom 10%, you'd much rather be a poor person in an economically free country than a poor person in an unfree country. And so that's why we need to really get South Africa up those rankings. It's currently languishing at about 94th, I think, or 99th. So that's a bit of a roundabout answer. But maybe, Mark, you're a philosopher as well as a lawyer. Maybe you could explore this idea of this positive versus negative freedom a bit more deeply.
Yeah, I suppose part of what you're getting at in your question is that you could care about these 3 things, and they could be in tension with each other. And so you've got to ask, do I really care about those 3 things? So to my mind, unemployment seems like something you should really care about, that we have frighteningly high levels of unemployment. And it would be much better if we were in a conducive labor environment so people could work. That would do a very good job at addressing poverty, partly because those that can work could then get the jobs, and then they might be able to assist those in their families that can't work. And as you mentioned, this might lead to some inequality. And the question is, why do you care about the inequality? So we could live in a very equal society, and we could live in Somalia, where everyone is equally poor, equally deprived. It doesn't seem good. You might think that inequalities are naturally going to arise, that they might also create a sense of aspiration, that if you can say, wow, if I put in the hard work, I can achieve this thing. So I don't think inequality in the outcomes bit is necessarily a bad thing. You might care about equality in other ways, so that you're going to be treated equally before the law, that regardless of your caste or your class or your race or your sex, you're not going to be discriminated against. That's the kind of equality I think you should care about. But it will necessarily be the case that outcomes are going to differ. And I think that's one of those things we must accept. I think you want to eradicate genuine evils like poverty. You could even imagine a society which have done such a good job at creating prosperity that people feel less inclined to work because they have the resources to engage in lives of leisure. So once we're ranking our values and start thinking what really matters, it seems like prosperity is the thing we care most about. And you want to design a system that gets there. I suppose as well, these indirect measures are a little difficult to explain. So as you said, well, yeah, everyone needs water, so I guess the government should provide it. And then you think, but it's our government, right? And they have what I like to describe as the reverse Midas touch. Everything they touch tends to rot. Whereas the private sector works incredibly well. If you have to choose between spending some time at a Home Affairs office or going to MTN, which one's going to be more painful? Competition sort of means that you're going to have better products, lower prices. Imagine if instead of having the variety of different phone manufacturers we just had government phone. So think about how much innovation you got from telecom in the last 60 years, which is basically none. You have a landline, that's it, versus the amount of innovation we've seen in the last 20 years from the private sector and phone technology. It's unbelievable. And how pro-poor it is. The fact that you can be a poor person and buy a smartphone for under 1,000 Rand and run a business off it is unbelievable. So private sector doesn't get enough celebrating in terms of tackling those goals of poverty and unemployment.
Yeah, I think there are always going to be different disparities in terms of people's income, but the question is, do you have a fair shot? I think merit is something that we need to celebrate in South Africa. As if you've worked your way to the top, you deserve to be rewarded for that. And if you're offering a valuable service or products to the market, then you should be rewarded for that. And I think there's nothing wrong with that. But yeah, if you get to the top because of your political connections and you're a tenderpreneur who's first in line because his mate works at the department, that's something that we should push back against. And that often leads to all of the other, the entrenchment of poverty and other things that people abhor so much.
If I could do a follow-up question.
Sure,
I understand the ideological arguments or the political arguments that can be made, but from my perspective, as the law stands, as my understanding, the courts have consistently upheld the idea that, well, it is in the Constitution that there is a duty on the state. These positive obligations are on the state nonetheless. Even though a person might believe that it might be not inefficient, the courts have time and time again said that this progressive realization rights are there and these duties are on the state. Likewise, with regard to equality, we might see inequality in where everybody's better off as not necessarily being a bad thing. Some might interpret judgments like Mutsenike's van Heerden to say that, but our constitution endorses the idea of substantive equality as a good in and of itself. And even if it infringes or encroaches on the idea of equality before the law, such that individuals will have substantive equality. So my question then, I suppose, is, given these ideological differences, how do we deal with the legal position in South Africa?
Good question.
It is difficult. I mean, I think you must recognize that judges are human beings who come in with an ideological character, and so have developed our law in a particular direction. So as I say, we've got non-racialism as a value. It tends to be ignored by our judges. That a lot are going to be quite left-leaning, so are going to be quite sympathetic to the idea of states running things, the hope that they'll do it well. At some point, that approach butts up with reality. And I suppose the question is, what are the prospects of having judges who, let's say, do a more careful reading of what the law might actually require? And I suppose who appoints the judges? Well, it's the JSC. So, what we've seen is that those that are bright and independent are kept away from benches. And if we continue down that track, we continue down, a pathway to hell. So that's where the lobbying gets useful, and that's why other kinds of constitutional litigation is useful. So keeping the JSC accountable is important, and there's been quite a few interesting litigation efforts on that front recently, because David Untold has been kept off the bench, and there's been threats of litigation and often reruns. So that is one way to kind of keep people honest. Diffusing power would make a big difference. So some of that just requires more political change, different kinds of people doing the governing. But that can't be done by lawyers. That must be done by citizens.
Yeah, I think the Legal Practice Council as well is, I think, a negative development that potentially politicizes the courts and creates a line of authority from the executive down to the judiciary. We want that separation of powers. And Mark mentioned the JSC. I mean, on paper, that doesn't seem like such a bad idea, right? Like that you have all these different stakeholders sort of selecting who becomes a jurist. But actually, in practice, what it's meant is, again, that becomes an arena of political contestation. And you have people like Julius Malema sitting on that committee and saying all sorts of harassing and horrible things to the judges. And then, you have to think, are the candidates for the court, do they have at the back of their mind, I don't want to upset this politician because maybe that will interrupt my progress up the judicial hierarchy. So we would advocate for the courts to have a lot more sovereignty over its own domain, and that the professions themselves choose who is representing them and who is part of their group. I think judicial independence is very important.
I have a question. Hi, I'm Emily Anderson. I'm the training coordinator at the Law Clinic. You mentioned at the beginning, and you have emphasized a few times throughout this presentation, that you're very passionate about private property rights. So I have a very ideological question, excuse me. How do you reconcile this passion about private property rights with the fact that majority of South African land is stolen land from the apartheid era?
Well, so South Africa has a long history of private property rights, but those rights have been very unevenly applied. And we also have a history of expropriation without compensation, to use a more contemporary term, right? So the Native Land Act, the Group Areas Act, these pieces of legislation did, in fact, abrogate that very important private property right for Black South Africans. So we, as the Free Market Foundation, are opposed to the dilution of private property rights. That's why we've stood up against EWC. But we are also, we recognize that everybody should have the right to ownership. And so we have a very important initiative called the Kaya Lum Project, which extends those private property rights to deserving South Africans. So if you take a step back in time to the apartheid period, many Black South Africans, because they weren't allowed to own private property, were tenants of the state. So they would rent from council properties, from the councils. And during the transition, F.W. de Klerk's government basically divested itself of all of these properties. So this was before 94, obviously. This was 1991. So the Upgrading of Land Tenure Act basically, with the stroke of a legislative pen, made these residents owners of their properties in which they've lived, sometimes for generations. That was a fantastic thing and a very positive development. However, many of these families who resided on these properties didn't have the legal title which proved their ownership status. So in 2010, the Free Market Foundation's Kaya Lum project, we ran a pilot study, which basically culminated, a pilot project, which culminated in 2013, where we successfully transferred 100 titles. 2013 was a significant year because that was the centenary of the Land Act. We transferred 100 of these titles to these owners. And that was the beginning of the Kaya Lum project. Fast forward to 2024, and we have now successfully transferred 24,000. Sorry, I said 2024. We transferred 13,000 of these title deeds. And why is that important? Well, that makes you, as a low-income, disadvantaged South African, part of you now become a beneficiary of the private property rights framework in South Africa. You have skin in the game. You are now an owner. You can transfer that asset to your children when you die. Most of the recipients are actually quite elderly. One person was 99 years old when we gave her title deed, and she had tears running down her cheeks. And she said, well, for the first time, she can now die knowing that her children will inherit her property. It's also very important for women. Often when, say, their husband dies, sometimes there's a family dispute over who inherits the house. If there's a title deed and it's clear in the husband's will, then that property can legitimately go to that person. There are also economic advantages. You can leverage that property to get collateral for a loan from a business, to run your business from a bank. So, Hernando de Soto, the Peruvian economist, wrote about how private property rights for the poor can be a pathway to more prosperity. So our opposition to EWC is informed precisely by South Africa's history of the dilution of private property rights. And so we stand very firmly in defense of that. And we will resist any attempts by this government or any other government to dilute private property rights again. And that applies evenly to everyone, not just the wealthy landed elite, but ordinary people in South Africa.
Just to add onto that, so I did a submission to Parliament on EWC, and I think you're right to be concerned about prior theft. And I don't think anybody who cares about freedom and property rights can condone acts of theft. But we must also recognize what's happened since the land claims process was opened up in 1995, which is that 1.8 million individuals were able to participate in a land claims process. They could say, this is my land that was taken from me, and they were given an option of whether they wanted the land back or whether they wanted financial compensation. And those claims were resolved. So there's a sort of rhetoric that nothing has been done, and that just isn't the case. So a large number of people have received compensation. Interesting enough, the rhetoric was, people have a hunger for land. 95% of people said, actually, I'd like the money, please. I don't really want a piece of rural land in the middle of nowhere. I want the money so I can start a business, so I can buy a piece of property in the area of my choosing. There's another kind of rhetorical claim about the land is stolen, which doesn't seem to track any kind of specific instance. So there are going to be cases, obviously, that David's mentioned, where the apartheid government just confiscated people's land, and obviously you must have redress them. And then there's something a bit more ideological, like the land was stolen in 1652 by the conquerors from Holland, and that doesn't seem to necessarily track how we think about ownership or particular individuals who've been deprived, or who would have a right to it, or what was actually owned. So I worry about that kind of rhetoric. But I think investigating real incidences of theft and then redressing them is very important. And again, it's a bit of a shame that a lot has been done to assist people with those redress rights, and it's not really being acknowledged. It also gives us a sense that we're much further down the track in achieving justice than we think we are. We must acknowledge that. And also, if you take the view that you want to protect the poor and the vulnerable, giving them property rights is a really good way to do that. And destabilizing them is a really terrible idea. So, you have, when I was cross-examining Mr. Malema in the hate speech trial, he sort of talked a bit about what the EFF would like to do. And they say, well, of course, no one will be an owner. The state will own everything. And we are the state. So as the vanguard, you can trust us. And we do have some experiences with these kinds of ideas before. So I find it kind of interesting that people are quite comfortable wearing hammers and sickles or waving those flags, given that 100 million people lost their lives in the horrors of communism. If you think about how many people died in Mao's China or in Soviet Russia, or at the hands of the Khmer Rouge, once you hand over enormous amounts of power to a small vanguard, they tend to abuse it. People aren't angels.
Thank you so much.
Great, thanks. Anybody else? Yes, sir.
Thanks. I just want to make a quick point, maybe. It seems to me, from what we've discussed and from what you're saying, it's incredibly important for organizations like yourselves to keep the government responsible, to bring them to task when they deviate from what is in the best interest of the country. I think from our perspective in our organization, it is maybe equally important to make sure that in giving those kind of liberties in the financial inclusion and what follows, that we also keep those who in private, in the capitalists who engage in exploitative practices, that we keep them responsible. And so maybe that's where organizations like the Law Clinic and other ones that render services to the indigent and the vulnerable are very important, because the adversarial system in which we operate, in which we all support, financial freedom, free markets, etc., that operates on the basis of the presumption that everyone has a fair shot at getting legal relief, that everyone is able to obtain justice through the legal system, and which we also know is just not the reality in the country that we are, for various reasons. And so therefore it becomes important that one then says, yes, we want those freedoms, but equally the responsibilities, as you mentioned, that we must then be responsible, and we, again, empowering organizations like the Law Clinic to say, we then need to be able to give people that access to justice that would necessarily mean that they're not now being abused by the new masters, the capitalists, instead of the old masters, the government, be it the apartheid or the new government, because they, again, don't have access to justice in the process. Thanks.
Yeah, thanks very much, Stefan. So the Free Market Foundation doesn't often advocate for state subsidies of things, but I would say that your point is very correct, that you need to give everybody access to the courts. And so I think having something like a law clinic that is well funded, I think is very important. I think the alternative proposals have been things like the price controls, like capping the fees that advocates, some advocates obviously get very well remunerated, and people look at that and think that that's very unfair. But then what you might do is you might drive the best minds out of the legal profession, or create some other kind of unintended consequence. So I think private charity is also very important, that you could have organizations that are specifically dedicated to the promotion of access to justice. I think that's really important. We are proponents of limited government, but the enforcement of the law and creating a capable judicial system, I think, is really where a lot of resources and energy should be going of the state, instead of all these other things like industrial policy that subsidizes European motor manufacturers to have a plant somewhere in the Eastern Cape, for example. I think obviously, as Mark mentioned, people are not saints. Just because you have a free market doesn't mean that people will stop defrauding one another or causing mischief. And I think that's where the courts play a very important role, resolving these kind of disputes. I think, Mark, do you have anything to add there?
Yeah, I think generally we should be wary about concentrations of power. And one of the benefits of a free market is that the powerful compete with each other, and that we find it's quite hard to maintain a monopoly for very long because you might fall out of favor. If you think about MySpace, this was the premier online place to sort of have a profile, which then got quickly dwarfed by places like Facebook, and you end up with a proliferation of different things floating around. I mean, sometimes you do wind up with a place like Amazon, which is the place to buy everything, but it's actually a marketplace for lots and lots of small people to sell their goods. It creates an enormous amount of prosperity to people who never would have had an opportunity to sell them before to a global audience. But I do think that keeping an eye on the powerful is a good idea, because they might very well abuse those powers. And having civil society checks and law clinic checks on those things is important. I suppose what is interesting is to have conversations with people who you might disagree with. I imagine that many of the things that David and I have said today will rankle. They will go against your intuitions. I think that's good. I think it's important to reconsider your intuitions all the time, to spend time with people who you might think are your foes, but actually care about the same thing through different methods. So David and I both care about the things you care about, which is the eradication of poverty and improving unemployment and making sure that there's greater prosperity for all. We might differ in the methods, and sometimes you can learn a lot from people on different sides. And so I would think that you might have set up, for example, big business as an enemy, but they might care about some of the things that you care about, and that there might be a new path to be forged on that front.
Yeah, I also think one of the reasons why we advocate for limited government is because big government raises the stakes for political capture, often by wealthy elites that want to lobby the government for special protections. And so a lot of the special pleading that happens in a big government, like I mentioned, the automotive manufacturers, the government thinks it's very important to have all of these big OEMs, the original equipment manufacturers, in the country, and obviously that creates employment and so on. But effectively, South African taxpayers are subsidizing German shareholders of companies like BMW and Volkswagen because of all of these subsidies, right? And so maybe that money could be better spent on other areas, right? And creating a more conducive business environment where investors want to come because they're going to make money, rather than they're getting some handout from the government, I think is much more important. So the bigger the state, the more the opportunities for rent-seeking behavior and big lobby groups, there's a big incentive for them to influence government for favorable policy treatment. So having a smaller government means that you lower the stakes. Yeah, so I think when people see concentration of capital and power, you have to ask, what is the source of that? Like, Facebook has made its money through providing a great service to users and advertisers, right? And I remember at one point Bill Gates was the richest man on earth, and then suddenly Carlos Slim overtook him. Carlos Slim was a telecoms titan in Mexico. And Carlos Slim made all of his money by lobbying the Mexican government for a state-enforced monopoly on telecoms. So, I think there are different ways of reaching that same outcome.
Yeah.
Audra.
Just one question from me. Just stepping back into the strategic litigation. So what lessons from the both of you can a law clinic like us learn from the strategic litigation that you've gone into? Looking at the advantages of doing that strategic litigation and the lessons that you've learned where cases haven't gone your side. So I'll take, for example, the case that you mentioned in relation to Malema. I know you're appealing that matter, but what lessons did you learn from it? And then the other cases where you mentioned that, I think you said AfriSac versus the Minister of Finance. So what lessons have you taken away from that which can assist us in our approach when we deal with strategic litigation? Thank you.
So I think part of it is you've got to work out what are your win conditions. Some of them are going to be getting a particular legal outcome, and some of them are going to be about changing people's minds and perceptions. So, for example, with Kill the Boer, there the client was acting for him. The process itself was an enormous achievement. So that trial was televised. There's an online record of all of it. For 6 days, South Africans could find out about farm murders in a way that is not generally covered in the press. They could find out the extreme nature of them, that they involve torture, that they disproportionately it's more dangerous to be a farmer than it is to be a police officer in South Africa, that you could get different kinds of evidence, so abstract evidence that gives you a sense of the law, the big picture. You could get testimony involved with selected treats from survivors and the effects on the communities, and hear from people who survived attacks themselves. So that kind of evidence is really important. Then there was Julius's evidence, which was to reveal the man to the public, to have him say on the record that he's not afraid of killing, that under the right conditions he would bomb the union buildings, that he doesn't think that killing a white mother and daughter in the most brutal possible ways, which included cutting off one of their breasts and writing "Kill the Boer" on the wall, is racist. Those sorts of things are useful to have on the record. As you say, the High Court decided against us in that case, and it's on appeal. And so there is an ultimate goal, which is, to hold Mr. Malema liable for the speech. And we shall see how that unfolds over time. But it did lead to a very interesting interim result, which is Elon Musk tweeted out to, I think, last time I looked, 38 million people, a short video of Mr. Malema singing "Kill the Boer" at a 90,000-seater stadium, and included cuts from our trial. And that seemed to cause enormous global alarm about the prospect of Mr. Malema becoming president of South Africa. That kind of press awareness, I think, is the thing you can only really dream of, to say, oh, this is a problem. This is something worth dedicating resources to and combating. And really, ultimately, if you think about the purpose of an Equality Court judgment on Kill the Boer, it's not just about regulating that phrase. It's about raising awareness. It's about saying, you've got someone who's got enormous amounts of political power, who seems to hold an enormous amount of animus to a small minority community, and that's worth taking seriously, and we should do something about that. It's about changing attitudes. And so the unfolding process has done that. So again, thinking about what your win cons are when you're running litigation is important. And seeing the litigation as one strand in it. So thinking, who's going to cover it? Do I trust these journalists to kind of understand what we're doing? Often journalists are not legally trained and misunderstand what it is that you achieved or what your methods are, things like that. Working out who your good partners can be. So from what I recall, I think the Black Sash are involved in your case, right? Yeah. So thinking about who can we work with, who can we share ideas with, what are the things that we missed? We might need a friend of the court to jump in and help us. So, for example, in the Afrisaka case, that's what occurred. They realized there was something they hadn't said, and it would be very useful to have another body come in and say that. And so much so that that's what the case was decided on, was what amicus had to contribute. I think knowing that you're in for a marathon is important. And so if you are reliant for, let's say, a decade on people to provide you services for free, that's going to be quite hard, and your case could collapse. So you need to be able to have people on side for a while. I think you can have changes on who works at the law clinic over that time. So being able to have a system in place that people know what the point of the case is and who you're dealing with and how to transfer the knowledge. And then working on, I think, in a deliberate practice way, what worked and what didn't work. What are the things that we would do differently from the get-go, given what we achieved at the end? And doing that on a regular basis. And I think looking at other case studies is a good idea. So thinking, okay, well, what did those guys do who might be our political opponents? For example, one of the things that I did in Kill the Boer was to try and mirror the trial structure of John Kulani's case. I'd acted for John in the appeals and wasn't present in the trial, but could see the value of the evidence that was led in that case and how it affected all the appeal court thinking. And so we duplicated that method. And that's the sort of thing that you can do. The duplication of the method led to a very different result in that, in Kulani, the view was you don't need a causal link between the speech and harm suffered, but apparently if it's Julius, you do. Mm-hmm. So you always run into those sorts of issues. I suppose part of it is not being disheartened, realizing that lower courts might get things wrong, and occasionally the Concourse is going to get things wrong as well. But and that even if you win, you might have pushbacks. So you might change the law, and then you could deal with the pernicious executive that's going to change it right back or find some other route. And so these fights are long.
Yeah, I think I would just repeat my earlier comment, which is to look for opportunities for leverage. Obviously, every case is important. There's an individual person's life who's involved in that, and you want to be as open as you can to helping those people. But I would say look for those big impact cases where you can make the biggest difference. But I'm not sure how much time we have left of this conversation, but I think unless there are any other questions, I think this would be a good point to bring things to a close. So I just wanted to say thank you very much to our hosts here at Stellenbosch University and at the Law Clinic for inviting us. I certainly learned a lot about your work as well, so thank you for sharing that. And I hope that we can speak again some other time.
From our side, again, David, Mark, very insightful. Regardless of on which side of the fence you're sitting, I agree with you. I always think it's good to get different perspectives on the table and to engage with them. So thank you for you and for Andre specifically for arranging it. Andre, we appreciate it. And then students and everybody else who attended, thank you for sitting in and for sharing. Unfortunately, there's no lunch, but sharing the lunch hour with us. We have 2 small gift packets that Stefan, will you hand it over to them? There you go.
Where? Oh, thank you. Wonderful. Pleasure. Thank you very much.